welcome to another episode of AP Government Crash Course. Today we're going to be talking about the judiciary branch and the different court systems that it has and how it works. So the judiciary branch is a passive branch which can only deal in real cases and problems rather than hypothetical ones, which is one way it differs from Congress and the executive branch, who could, for example, put forth a law addressing a hypothetical issue and something that hasn't actually happened yet. And because of this, the judiciary branch is a passive branch. Something else needs to happen before it can actually take action. But where does the branch get its power from? Well, there's only actually one court that is specifically mentioned in the Constitution, and that's the Supreme Court, of course. The other federal courts, like the appellate court and the district courts, are created by Congress, which is an example of a check on the judiciary branch. So when hearing these cases, something that often comes up is jurisdiction. There's four main different types of jurisdiction. Firstly, there's original jurisdiction, which is the first court that hears the case. They have original jurisdiction. The second type is appellate jurisdiction, and that's courts that don't have the original jurisdiction have appellate jurisdiction, because the case, they got the case from whatever court was below them. So the court below them had to appeal that case up to the next court for that court to have appellate jurisdiction. Next type of jurisdiction is called exclusive jurisdiction, and courts with this deal with cases that can only be heard in these certain courts. For example, the U.S. district courts have exclusive jurisdiction on bankruptcy matters. Concurrent jurisdiction is when there are cases that can be heard in both state and federal courts. Now, we mentioned district courts, and there's actually three different types of court systems, the first of which actually being district courts, of course, which is the most abundant type of federal court. There's 94 different district courts, which have just under 700 judges employed by them. Every state has at least one of these courts. Obviously, some have more than one. And, of course, these are the most popular, and they handle about 80% of all federal court cases. Very few cases are actually decided by trials, and about 98% of the defendants actually just take a plea bargain, which is just when a defendant admits they're guilty so they get a more lenient sentence from the prosecutor, and at that point they don't have to actually go on trial because they've just admitted guilt. But these district courts actually, they do have the power to go to trial if they need to. The second type of court is the circuit court, which is also known as the Court of Appeals. The circuit court is an appellate court system, and so it's also known as the Court of Appeals, which I defined just a moment ago, and who are responsible for reviewing all district court decisions. And so that's why, once again, those cases come from below because they're reviewing them. That's why they're an appellate court. There are 13 district courts, so much less than the 94 district ones. And circuit courts do not hold trials like district courts may, or hear testimony, but something that they are able to do is rule on decisions relating to federal agencies, like the Federal Communications Commission, for example. This is one example of a judiciary check on the executive branch. And lastly, the most powerful court is, of course, the Supreme Court. There's, of course, one federal court who are in charge of reviewing cases from the certain courts, which is, again, called the Court of Appeals, and state Supreme Courts. And did I mention that every state has a Supreme Court as well? The Supreme Court gets cases with original jurisdiction only when the case involves multiple states, or the federal government versus state governments, or also when the federal government is going against foreign diplomats. But again, very few cases are actually reviewed with original jurisdiction. Most are heard with a writ of certiorari, which is when the Supreme Court orders lower courts to send their cases up for review. In addition, the rule of 4 designates that at least 4 of the 9 justices have to agree to hear the case. So they really do get a chance to kind of decide what cases they want to hear, giving them a chance to kind of set the policy. Another way that they can set policy is through their power of interpreting the Constitution. And whatever decision that they make through this interpretation, future justices will have to follow. The Supreme Court also, of course, has the power of judicial review, which is a judiciary check on the legislative branch to find legislation unconstitutional and then declare it invalid. With regards to how a person actually becomes a judge, another check that is placed on the judiciary branch is that all federal judges have to be appointed by the president and then confirmed by the Senate. We've seen this part of this process already with Trump's nomination for the Supreme Court, Neil Gorsuch. In the federal court system, there are two main philosophies: judicial restraint, advocates that the Supreme Court should only use past court decisions, also known as precedents, in the framer's original meaning when deciding cases. Their reasoning, and something Scalia would champion, is that change should come not from the judicial branch, is that it should come from the elected bodies such as Congress and the President through amendments and laws. The second of which is then judicial activism, which advocates that there is a branch's responsibility to correct wrongdoings done by the other branches of government. A great example is Brown v. Board of Education, wherein through judicial activism, social change was brought. One good thing to know about judicial activism is that there was a very powerful period where judicial activism was very prevalent, and that was during the Warren Court period, during from 1953 to 1969, when Earl Warren served as the Chief Justice of the Supreme Court. He presided over many very famous cases, such as Brown v. Board of Education, but then also Miranda v. Arizona, and several others, dealing on very many different social issues that kind of paved the way for many different other things. One last thing I want to end on is the impact of public opinion on the judicial branch. So essentially, the founders set up the Supreme Court so that they serve lifetime terms, meaning they don't have to worry about the public directly voting them out of office like someone in the Senate or the House would have to do. And this way, they're able to make decisions that might be controversial, but that still have the benefit of the nation in mind, and so they don't have to worry about rerunning for their office. They also don't have to collect money from lobbyists to rerun for their office every 2 to 6 years. Justices, however, can still be impeached if they do deviate too far from the public's ideal goal, but a justice has never actually been impeached and then punished before. I really hope you guys enjoyed this episode of AP Government Crash Course, and I guess I'll see you guys next time. Peace.